having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Your Honor, if your tendency shall be heard. God save the Commonwealth and National Court is open. Please be seated.
Good morning, everyone. My name is Vicki Henry, and I'm your panel chief today. It's March 2nd, 2026, and I am delighted to be joined on my right by Justice Shin and on my left by Justice Toone. My pronouns are she, her, and judge. You are welcome to share your pronouns or not as you see fit. We're hearing argument today in 5 cases. We'll take a morning break at the end of 3 cases. For better or for worse in the appeals court, we don't have rebuttal. And also I can assure you that we have read all your materials quite thoroughly, so I'd encourage you to get to the heart of your legal matter. I know myself and I know my colleagues, we usually have questions, which I encourage you to think of as a good thing, because it helps us to understand your argument. And with that, I'll call the first case, which is 2025 P. 159 Commonwealth versus Matthew Combes.
Please support Adriana Contertesi for the defendant appellant, Mr. Combes. Mr. Combes contends an insufficiency of evidence to support his conviction, and that being the case, he is entitled to vacatur. This is very important to the defendant. This is a very unfortunate case with an unfortunate result. Even he had been offered pretrial probation, decided not to accept it, and even if the law does make this an uphill battle, it can't be said that justice was done in this case, especially in light of these facts. First of all, the defendant, at the time this incident happened, he had a plastic cast on his leg. So I think that that has to be factored into the assessment of would a reasonable person actually be in fear. Secondly, it was pretty much uncontroverted testimony that he never swung the bat. Third, the victim never appeared in court, and fourth, it was conceded that the victim spat in the defendant's face. So I concede that the Commonwealth is correct on page 9, and that being the case, I have to withdraw argument 1 that I present that relies on the fact that the judge said that she didn't see an attempted battery. So that's my mistake, so I'm withdrawing argument 1, but I don't think that that prevents the court from considering argument 2, which was the insufficiency on both the attempted battery and the threatened battery theory.
So the Commonwealth says the defendant, I mean, from what I saw in the video, the defendant did not swing the bat. He was sort of, wielding it, but not swinging. But the Commonwealth argues he didn't need to swing the bat in order to find him guilty. So what's your best case that he did need to swing the bat?
Budising. The Budising case, and I cite that quite often. In the Budising case, he did swing the bat and the mother interfered and stopped that. When somebody is just holding up a bat and in addition they have a cast on their leg, I just don't think that holding up a bat would be enough, especially in a circumstance.
I thought in Budising he did not swing the bat, that he raised it and then the victim's mother intervened. Isn't that?
Victim's mother interfered.
So he didn't swing the bat in Budising either, right?
Did the victim's mother swing the bat? I can't.
I mean, that's all right.
I think you're right.
Okay.
I think, pardon me. And sorry for that slip on the facts, but in Budising, the victim did hold the bat up menacingly. But it was sufficient, the fact that the mother intervened, I think was sufficient to show that it was menacing enough that the battery was imminent.
Couldn't the jury infer here that the bystanders intervened?
Well, that is what the judge, one of the things that the judge found. And that I think is another factor in Buddhising that would indicate that somebody found it menacing. In this case, though, was it reasonable to find that even holding up a bat would put a reasonable person in fear of a battery when somebody has a plastic cast on their leg and obviously doesn't have full mobility?
So I can see in the transcript that defense counsel asked if the witness saw the cast, and they said, like, at that point, no. So I'm not clear it's in the record that the defendant had some sort of cast.
Well, so much isn't clear in the record because the victim never turned up. And I think that goes to, the justice of the injustice of the trial and the conviction. I don't have anything else.
Well, just on Commonwealth versus Andrade from the SJC seems to say we affirm the conviction if there was sufficient evidence of either attempted battery or threatened battery. That's
Yes.
Do you agree with that?
Yes, the Commonwealth was correct on that.
Okay. Well, on the video, the Commonwealth, I mean, we've seen the video, but the Commonwealth summarizes it as showing the victim was walking away. The defendant charged the victim with a bat raised while repeatedly shouting, "Come on." Do you have a different characterization for us to consider?
Well, I think that my facts are different because my facts do set that out in a different way than the closing argument set it out. And I think that it's really for the fact finder what was in the video.
Mm-hmm. We understand your position. Thank you very much.
That being the case, if the court can see its way to vacating this conviction, I know I can get this straightened out in the trial court. Again, this was a case where the defendant had been offered pretrial probation, so I think everybody understood that the evidence was flimsy at best and there was injustice to this conviction. Thank you.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Matthew Padalano on behalf of the Commonwealth. Given that the defense counsel withdrew the first argument, I think I will brush past that unless the Court has questions.
I just want to, what happened exactly with the ruling on the required finding motion? Because it did seem from my reading that the judge did not intend or didn't think there was sufficient evidence on the attempted battery theory. Do you disagree with that? I mean, I know there wasn't an exact ruling on that, but it seemed that's where she was going.
So I believe there is an explicit ruling on that. So on page 70, I believe I cite this on my in my brief, but the judge says, your motion for a required finding at the close of the Commonwealth's case is denied for all those reasons.
Right, but that comes after, there's a very detailed discussion of the other theory, right, of the immediately threatened battery theory, which clearly the judge did not intend to grant the motion on. I'm just kind of confused
Sure.
because there was this initial discussion where it seemed, my reading, and I realize there isn't a ruling on it, but
Sure.
it seemed that she did not think there was sufficient evidence on the first
So I believe that ruling was meant to encapsulate both theories, and then there's a discussion where the judge is sort of thinking out loud about, oh, I can see your points, I understand the points you're making, but ultimately decided against, I think the judge was sort of thinking out loud and allowing the defendant to understand that they had been heard on their arguments. But I think the ruling is pretty clear that the motion was denied.
What is the best evidence that there was an attempted battery?
So I can go through the
Just
elements.
what would you, I mean, we've seen the video, what shows an attempt as opposed to immediately threatened battery?
Sure. So on this, you can see that the defendant is charging. You can see it has it raised above his head, and he gets very close given that the victim sort of raises their hand in defense. And I think the Buddhism case, I think, stands for the proposition that you do not need to swing a baseball bat in order to get an attempted, I mean, candidly, a baseball gets hit once with one swing, so you do not need to swing it multiple times in order to have an attempted battery. And I think given that they were later found being sat on by civilians, I think that sort of evidence is that they were prevented from completing that attempted battery, and they got, substantially close.
So the overt step towards accomplishing the intended battery
Is the charging, is the having it raised above the head, is getting very close to the person who is retreating away from you. I think that's enough for an overt step of, and, again, this needs to be in the light most favorable to the Commonwealth, under the Lattimore standard, and also in the context of yelling, "come on," while charging the victim, essentially.
One could argue, though, that the come on was sort of the opposite, that he was not going to swing unless the other guy swung first.
I suppose it's open to that interpretation, but I would say that under the Lattimore standard, we have to read the evidence in the light most favorable to the Commonwealth, and although that might be one potential interpretation of the evidence, another very reasonable one is sort of fighting words in preparation for a fight, especially given that one person is armed and one person is not armed. I think it sort of sets up the proposition that he is preparing to strike. And I was going to get to this later, but again, I think the Andrade case stands for the proposition that even if this court were to find that there's insufficient evidence under the attempted battery theory, Andrade stands for the proposition that if there is sufficient evidence of one of these theories, and it is a general verdict, which on trial transcript 99, this is a general verdict, that the conviction should still be upheld.
So you agree, though, the defendant never swung the bat?
I agree that he never swung the bat. He is waving the bat in what I would argue is preparation for a swing. And again, you only need to swing the bat once to actually hit somebody. I don't think that someone should be required to have swung the bat at a person to get an attempted battery conviction. I don't think that's what the Budison case stands for.
So one of the things I found confusing as I was reading our case law is obviously I understand what the SJC said in Andrade, but in Commonwealth versus Carvajal, which was decided just this year, or just last year, there the SJC vacated a rape conviction because the jury was given 3 alternative theories of aggravated rape, and only one of the theories was supported by the evidence. So I'm trying to understand how to reconcile these cases.
I don't have that case in front of me. My assumption would be that it's because it's not a general verdict. I think you need a general verdict so you do not know which one the jury decided it on. Not having that case in front of me, I wouldn't know that off the top of my head, but that would be my assumption of the difference. And I think...
What do we do if it was a general verdict? I don't remember.
So if it's a general verdict, the assumption is that you cannot decide which way a jury, what theory the jury convicted under, and so if you have sufficient evidence of one, then an appeals court reviewing the record would have to decide that they must have decided it based on the one that there is sufficient evidence for. And I think that stands up to common sense logic.
Right, that's what I'm struggling with, and I'm looking at my note that does seem to indicate it was a general verdict in that case, too.
It was, yeah.
Okay.
Okay, so yeah, I don't...
And you acknowledge that we're dealing with different theories here, right? These are
Yes,
different
these
theories
are
of liability.
different theories, and I think that is sometimes confusing in the case law, that sometimes they're described as theories, sometimes they're described as paths, but I do believe that Andrade is the most on point, given that it is the same a theory of assault and battery. I understand that there might be other SJC case law on other types of theories, and it might just be that those theories are treated differently than these theories. Unfortunately, I can't make sense of the case law if it's in contradiction and where one doesn't necessarily overrule the other. Given that,
Points for candor on that, I think.
Given that, however, I would say that where there is direct SJC case law on this theory and these theories, that I would have the court defer to that case. If there's another case that deals with other theories on other types of convictions, I think that's necessarily less on point.
So what about her just general argument, this really was unfair? The victim here spit first in the other guy's face, and then the victim doesn't even come to court.
I understand that argument. However, I think that what the defendant is describing is essentially revenge, because in this instance, there was a spitting, the victim walks away, and only then is he charged with a baseball bat by the defendant. If that were to be the court's ruling, then essentially anyone who shows up an hour, 2 hours a day later and hits somebody for a previous slight, that would be found to be self-defense in some sort of way. I think the video is very clear that the victim had essentially left the scene. You know, there had been a spit in the face, clearly based on some sort of road rage, and then had left, and only then did the defendant charge. And so I think that sort of rules out any sort of potential self-defense. And even still, I don't think that that argument is fully fleshed out in the briefs. I think where the brief is mostly describing a sufficiency purpose, I don't see how the spitting weighs into the sufficiency of the evidence. So that being said, the only other thing I'd like to address is I know the big point of sufficiency that the defendant makes is that the victim's distance can't be told based on the evidence. As I described in my brief, you can see what the victim is wearing earlier in the video. Then later in the video, you can see the victim's arm in the very corner of the video. And so I think it's inferable the distance between the defendant and the victim. And so he did come very close to completing this battery and was only prevented from doing so by innocent bystanders sitting on top of him, essentially, and preventing him from completing that battery.
Your screenshot was very helpful on that.
Thank you. If the court has no further questions, I'd be happy to rest on my brief. I think the evidence in this case is quite clear, and I would ask the court affirm the convictions.
Thank you very much. We understand both sides' arguments. The case is submitted.
Thank you very much.
Our next case today is 2025 P689, Commonwealth versus Renie.
Thank you, judges. My name is Chris Norris. I'm here speaking for Mr. Jason Renie. He's at MCI Shirley this morning.
Could you speak up just a little bit?
Sure. My name is Chris Norris. I'm here speaking for Mr. Jason Renie. He's at MCI Shirley this morning. Thank you for inviting me to your court. The culpable mental state for a crime is an element, meaning that it requires jury unanimity. And so from Commonwealth v. Santos, we know that when the Commonwealth prosecutes a single crime that use distinct theories of culpability based on a different mental state, a specific unanimity instruction and a special verdict slip are necessary to ensure that juror unanimity. There are two examples of that situation that I can point to where the theories under a single crime are substantively distinct because they're based on a different mental state. First-degree murder under theories of deliberate premeditation, extreme atrocity and cruelty, and felony murder. Commonwealth v. Berry said that prospectively the jurors had to be unanimous on which theory of murder they agreed on to convict. And I'd point the court to the instruction for first-degree murder. Deliberate premeditation requires a decision to kill. That's distinct from extreme atrocity or cruelty, which requires malice. Those are two different mental states. Even more stark, in Commonwealth v. Acida, the court found that when a defendant is simultaneously prosecuted for voluntary and involuntary manslaughter under that single statute, a proper verdict requires instruction on jury unanimity in that special verdict slip. And the distinction in mental state is even starker there. Voluntary manslaughter is an intentional killing. Involuntary manslaughter is an unintentional killing caused by reckless conduct.
The difference in mental state could not alone be dispositive of this question, right? Because, I mean, as you just heard in the case before, the SJC has said, and I believe we have said, that threatened battery and attempted battery are not substantively dissimilar. The SJC has said principal liability and joint venture liability are not substantively dissimilar. So where do we draw the line?
Well, I would refer you, Judge, to the argument that's made in United States v. Tavares, and
Right.
they discuss the Poro case. And what the court, what the Circuit Court of Appeals says in United States v. Tavares about that is that the mental state under attempted and threatened battery are closer and sometimes overlap. And so that condition, that they're closer, that's what the court says in that case, and that they can overlap, meaning they can simultaneously coexist. That distinguishes that situation, the Poro case, from what I'm going to suggest is a proper analysis under assault and battery with a dangerous weapon.
I mean, it
Attempted
seems
battery-
quite analogous to me, the difference between attempted and threatened battery versus intentional and reckless ABDW.
Sure, and that's a great question, and that's precisely what this situation comes down to. And again, I would go back to United States v. Tavares because I think it's the correct and reasonable analysis. Attempted battery is the mental state where you have the will to commit the battery and you take an overt step. Threatened battery is very similar in the sense that it's the desire to commit the battery and some action that communicates that. Those are close and they can overlap. In a single act, a person could be committing an attempted battery and a threatened battery. Those two mental states can coexist. Assault and battery with a dangerous weapon, first-degree murder under the theories of deliberate premeditation and extreme atrocity or cruelty, and voluntary and involuntary manslaughter, those mental states can't coexist because in some sense they're contrary. An intentional act is more distinct from and even contrary to a reckless act. An intentional assault and battery occurs where my mental state is with the intent to touch, commit a battery on a particular person. A reckless assault and battery with a dangerous weapon doesn't have that intentional mental state.
But they can coexist, right? I mean, you can intend the act recklessly and still have the intent to injure, right?
Well, right, but the difference is in the intentional assault and battery with a dangerous weapon, my intent is to batter a particular person.
Right. Yeah.
Recklessness is the intent to engage in an act, say swing a baseball bat around, but I don't have the intent to touch a particular person.
You might not, but you could, right?
Could have that intent?
Yeah.
Well, if I did, then it would be intentional.
Well, but here, under either theory, it seems like the defendant intended to swing his knife at the victim. Is that wrong?
Well, I don't know that I completely agree with that. I think that there are two ways to look at the specific factual situation. It's sort of the moment of truth in this case, or the key fact for determining Mr. Rennie's mental state. The victim testified about an intentional ABDW. Face to face, he took the knife and stabbed me in the eye, right? Mr. Renie testified about recklessness. He was out of breath, seeing stars, losing consciousness, that kind of thing, and swung the knife around. He said that he didn't.
I have watched the video in this case too, and I guess, I mean, the briefing dances all around it, but I mean, in the video, it doesn't seem like when the victim is swinging his arm, he gets anywhere near when the defendant is swinging his arm, it doesn't seem like he gets anywhere, and he's in the headlock, that he doesn't get anywhere near the victim's face. So then that's why if the strike was definitely when they were both upright.
Right. Well, and that's an excellent point, and I think that is exactly why the correct thing to do is for this court to vacate the conviction and send it down to the trial jury to make a decision with the correct instruction. We don't really know exactly what happened based on all the sources, the video, what people are saying, the different parties. It's like a Rashomon situation, right? And it's made more complex and confusing by the way the trial court judge instructed the jury about how they're supposed to think about his mental state at that key moment to decide whether to convict, acquit, how to evaluate his self-defense. The jury's left in a situation where they don't know if they're supposed to evaluate his conduct as being intentional and what that means and how that connects to a self-defense claim. What if it's reckless? How do we evaluate that? How does that connect to a self-defense claim? And I think that exact confusion is the reason that this court ought to agree with me, vacate the conviction, send it to the trial court for a trial, and with the specific unanimity instruction in a special verdict slip, it will be much cleaner about what the jury thought and how they evaluated Mr. Rennie's conduct.
So Mistretta was decided in 2013.
Yes.
Tavares was decided 2016. It's been 10 years. I found several cases since in those 10 years that have followed Mistretta. So why should this case be the case for us to reverse course?
Because I think that it's an important issue.
I agree, but
It's a very-
you know, it's not. It's a difficult issue, and to overrule one of our cases that has been followed for over a decade, what would be the standard for that?
Well, it's because it's, in my view, it's not correctly decided. It's been followed, you know, I can't disagree with that, but I don't think it's correctly decided. And I think that the force of the logic from United States v. Tavares is, it's the correct logic. It's the correct view of the law. It's the correct view of the framework that's established in Santos to resolve these types of questions.
And the judge, Mistretta has been incorporated into the model jury instructions, correct, right?
Yes.
And that's what the judge relied on here, right? So it really is kind of settled in a sense. And I understand that the argument, your logic still exists, and Judge Cayeta's decision in Tavares is very interesting. It's just very difficult for us to sort of say that this established decision, we're going to reverse it and undo everything that's been done in reliance on it. What makes this case unique? What makes this case a good vehicle to sort of consider that unusual step?
I think because the issue is presented nice and cleanly, I think the attorney at the trial court did a good job of raising this issue, including citing to Tavares, explaining why on these facts Tavares is the correct view. The trial attorney at the charge conference explained that he was concerned about juror confusion here in the way that the two theories of ABDW would be instructed on. I think that these facts beyond that present a need for this court to take what I would suggest is the correct action, because you have a situation factually and in the record that is so very confusing. Different parties, probably based on their own interests, are describing this situation in different ways. You have a video that, you know, doesn't seem to definitively support one party or another. And in that confusion, the way to correct this situation is to send it back to the trial court to have the judge instruct more clearly to the jury so we can determine what exactly the jury is finding with respect to Mr. Rennie's state of mind and his conduct, and properly evaluate his self-defense claim.
So I think the Commonwealth is arguing that while you might be right if this was just an assault and battery by means of a dangerous weapon, but where it caused serious bodily injury, your argument doesn't work anymore. They're relying, I think, on Commonwealth versus Welch. So What do you say to
Oh,
that?
I think it's the opposite of that, because if you look at the ABDW statute, they talk about this sort of balance. An intentional ABDW is a touching, but an injury is not required. How does that coexist with reckless ABDW under the same statute? There is a reckless act that results in a touching and some kind of injury. So there's some kind of balance here. Now you get assault and battery with a dangerous weapon, serious bodily injury. You have an intentional mental state and a reckless mental state, and there's no longer any balance. Think about it like this. You're a trial court judge. Okay, in this situation, the jury comes back and convicts Mr. Renie. How do you sentence him? I would suggest to you that an intentional criminal act is more culpable than a reckless criminal act. Just like an intentional voluntary manslaughter is more culpable than an unintentional involuntary manslaughter, and the sentencing would be different. But in this case, we don't know what the jury thought.
So the reason the First Circuit in Tavares held the way that it did was because it was trying to predict what the SJC would say on the issue. Do you think that the fact that this has been in the model jury instructions for quite some time, that doesn't have any bearing on that question?
With respect, I don't know how to answer a question like that. That's for the judges.
Well, I'm asking you because
Oh.
you're asking us
Right,
to
but-
follow Tavares,
okay.
which is trying to predict what the SJC would do, and I'm asking, do the model jury instructions not bear on that question at all about what the SJC would decide?
No, because the logic and reasoning in Tavares is strong enough to overcome any of those considerations. And with respect, those are considerations that I'm not, I can only speculate about.
Do you know when Mistretta got incorporated into the model jury instructions?
I don't know the answer to that. I would imagine sometime shortly after the case was decided in 2013.
I guess what I'm trying to nail down is, do you think it was, if you don't know, that's fine, we can look, but whether it was before or after Tavares?
I would imagine that it was, I would think, and I can't really articulate it in a forceful way, I would think it was before Tavares.
So one other question, and we'll hear from the Commonwealth, but they argued that there was no prejudice here because the prosecutor consistently and exclusively presented the case as an intentional assault and battery. What do you say to that?
I think it makes the jury even more confused, because if that's the case, you know, the issue should have been narrowed and they should have been instructed in a very clean, simple, clear way.
Thank you very much.
Thank you very much.
We'll hear from the Commonwealth.
Good morning, and may it please the court. Jesse Crane for the Commonwealth. The trial judge correctly denied the defendant's request for a specific unanimity instruction and a special verdict form. The judge instructed exclusively on ABDW SBI, and the defendant was convicted of ABDW SBI. That additional aggravating factor is important here because, as the SJC explained in Appleby, Section 15A describes a general intent crime. So all the defendant needs to do is intend to do the act that causes the injury. Unlike simple ABDW, there is no substantive difference where the victim suffers serious bodily injury, because, as is explained in Welch, where the reckless form of ABDW is at issue, there needs to be some form of physical or bodily injury. That requirement is erased by the SBI element, which the jury found unanimously here.
I see your point that the injury distinction kind of washes out in this situation, but you still have the intent distinction at the front end, right? I mean, that's recklessness versus intentional.
Right. I think to use the terms that are used in Tavares a little bit, recklessness and intentionality are factual predicates that can satisfy the general intent element to complete the crime. So the jury doesn't need to agree on those factual issues. They just need to agree that the defendant acted purposefully when he set in action whatever that was, the course of events that resulted in the injury.
So, first of all, were the parties contending that the injury to the eye occurred at a different time, with you saying it was before the headlock and him saying it was after the headlock?
I would say that's correct. I think at trial, the prosecutor advanced the theory that was supported by the victim's testimony and his friend Nick Stornis, that there was sort of this initial phase of the fight where they're both standing up. The defendant goes to punch the victim, and the victim reports, all of a sudden I couldn't see out of my eye. The defendant had a slightly different version of events, but I don't know that it's a meaningfully different version of events. He claims he's in a headlock. Presumably the victim is holding him in the headlock. He pulls out one knife from his back pocket, drops it, pulls out a second knife from his back pocket, and he says, I just swung. And on cross-examination, he says, I was trying to get whoever was on top of me off of me. So I really think under either version of events, we're talking about an intentional battery. I understand that the defendant's testimony, I think, straddles the line a little bit. And I'm thinking specifically in terms of the Lewis case, which I cite, where the defendant there kind of just blindly kind of swings a knife behind him at someone, knowing that someone's touching him on the shoulder. So I think in
What did Lewis say? What was the holding?
Lewis said it was a sufficiency claim as to whether the defendant had recklessly committed ABDW on a person over 60. And Lewis is one of those post-Tavares cases, actually, that cites Mistretta directly to say that the court didn't need to analyze further whether the defendant's conduct.
But it was under a reckless theory.
It was under the reckless theory, but the court specifically in a footnote cites Mistretta saying they didn't need to go further and analyze whether this qualified as an intentional battery
On the
as
question of what theories were presented to the jury, it seems that the defendant's theory could be either intentional or reckless.
I would agree that the defendant's theory could be either, and I think that's why it's appropriate that the judge instructed on both, but I do think it depends on what the Commonwealth is advancing, really. I think that's what Santos requires. And I think also the defense, the real heart of the defense was a self-defense claim. It really was that the defendant was saying, I was being attacked on all sides by multiple people. I was panicked. I thought I was going to pass out. So I pulled out a knife and I swung at my attackers. So I don't see that it's particularly meaningful to the verdict.
Well, what if the jury disbelieved the Commonwealth's argument that the stabbing took place before he was in a headlock? Maybe that's not reasonable to assume based on the video. Judge Henry seems to have been able to ascertain what happened better than I did from watching it. But let's say it's not reasonable. Well, let's say the jury disbelieved that and found that the injury occurred during the scuffling with the headlock. Then the jury would not have to be unanimous whether he's acting intentionally or recklessly.
I would say no, because again, it's a general intent crime, and where the SJC has consistently explained ABDW has two aspects, and the reckless aspect requires a showing of injury. Well, we have a showing of injury. It wasn't disputed. The jury did find that element. We're sort of just splitting hairs at that point where the statute doesn't require one or the other really for an element. It's the general intent element. So I don't think it's particularly dispositive whether the jury agreed with the defendant's version of events that he swung and stabbed the victim while he was in the headlock versus when both he and the victim were kind of upright and on their feet at the initial point of the fight.
So he argues, I mean, why, I guess, why is Tavares wrong?
I think Tavares misses that this is a general intent crime. That's the big error that I can see. I recognize that maybe this is a closer question for simple ABDW. But at the end of the day, even still, simple ABDW is a general intent crime. So the defendant's mental status, again, may just be a factual predicate to satisfy that single general intent element. And I guess I would just note, as far as Tavares' comments on Mistretta and what the SJC would do, the SJC did deny FAR for Mistretta. So I don't know that it's totally a mystery.
Well, some of us might think the SJC occasionally denies FAR when it should have granted FAR.
Fair enough.
So simple assault and battery is more difficult because of the injury element for reckless? Is that what your argument is? But here, because it's SBI, it doesn't matter.
Yes, I think that's the intellectually consistent position for simple ABDW. I think
So Mistretta was wrong then, because wasn't that a simple ABDW?
it was. I'm not conceding Mistretta was wrong and saying Tavares was right. I think it's a closer call. I think Porro provides plenty of support for the idea that simply having different mental states isn't quite enough to say you need a specific unanimity instruction. I do think that there are things that trial judges could do in light of the facts of an individual case to avoid some of the concerns that Tavares points out. I think whether or not the extent of the injury is at dispute is probably an important factor for how trial judges should form their jury instructions. I don't know that I'm ready to go beyond saying that as far as the dispute between Mistretta and Tavares.
Just a very odd situation to have this. We're in something of a limbo, right? We have a ruling, First Circuit, which we're not bound by, but has a very unusual ruling saying that we got it wrong in interpreting Massachusetts law, and the SJC would likely disagree with us. And that's hanging out there. This has been incorporated into the model jury instructions. And the judge here quite properly relied on those model instructions and that precedent, but it's just a very difficult situation to sort of, because this argument's going to keep coming up again and again. Do you have any suggestion as to how this could get resolved?
Well, I think your honors were asking my brothers why this case. Is this the right vehicle for overturning Mistretta? And I think the answer is no. This was an aggravated form of ABDW that sort of erases the substantive distinction that Tavares explicitly relied on. I think also Tavares is addressing a different issue than this to a certain degree. It's obviously talking about whether ABDW, simple ABDW specifically, so already it's differentiable, but whether it's a crime that requires the use, attempted use, or threatened use of violent force under a federal sentencing provision. I think it would be a little bit too much to go out on a limb on this case to say Mistretta was wrong. We should just adopt the analysis in Tavares.
Oh, sorry.
No, I mean, I don't remember now whose brief it was, but I mean, you know, I just copied out the elements for intentional ABDW and reckless ABDW and put them in a chart side by side, and then it didn't seem like the different elements lined up. So then I tried to put them in a second chart where I mapped them out, because they're like, it's like a chart where the arrow is going from element 6 to element 4. Like elements 5 and I'm like, well, this isn't even the right standard because it was actually ABDW with a serious bodily injury. But I mean, it's there are 6 elements, but they are not the same and they do not line up. I mean, obviously the recklessness is different, but even just lining them up, they don't line up.
I did the same exact thing. I understand the problem that you're pointing out.
Yes.
And I think I would just say, at the end of the day, the focus needs to be on the actual conviction and what the jury was instructed on, and where that SBI element subsumes that kind of meaningful distinction, and we're dealing with a general intent crime. I think it is very complicated when you look at all the lesser includeds of ABDW, and then just simple assault and battery, and then even down to the different theories of assault. But the focus needs to be on what the actual conviction was and what the jury was instructed on. And when you look at it only at that level, it becomes, I think, very clear that we're not really even dealing with two different theories of a crime. It's just two different mental states that satisfy one single element, and there's no meaningful difference between them.
Do the model jury instructions answer this question about whether specific unanimity is required?
I should have reviewed the model jury instructions. I have not read them in some time, so my candid answer is I don't remember. My memory from reviewing my brief, however, is that it does say there's not a required specific unanimity instruction. But I think the SJC's cases are, and this court's cases are clear. Where you're dealing with a single incident, you don't necessarily need a specific unanimity instruction.
And I take it you don't know whether Mistretta was incorporated into the model instructions before Tavares threw up its warning flag?
I do not. I apologize. If there are no further questions, I will rest on my brief. Thank you.
All right, thank you very much. We understand your arguments. Then the matter is submitted. We'll call our third case for today, 2025 P668, Commonwealth versus Benevides. And if I've mispronounced that, feel free to correct me.
May it please the court, Eric Rubin for Mr. Benevides. This is a sufficiency argument. But before I get too deep into my argument, I just want to address a couple of things about the Commonwealth's brief that are important to me or my client. First, the pelvic touching, I always feel awkward about these things, and I apologize to the court. But the pelvic touching was not part of this crime. The Commonwealth refers to it in her brief several times, but in the opening and the closing, the Commonwealth does not include it.
I thought the prosecutor did refer to both the touching of the pubic area as well as the rubbing of the inner thigh. Both instances are mentioned in the prosecutor's
opening of, I'm sorry, Your Honor.
In the prosecutor's opening statement, aren't both mentioned?
On page 62, the Commonwealth says he realized where his hand was, said, "I'm sorry." She said, "That's okay." And in her testimony, which I believe is more controlling, she said it was clear to her that it was an accident. He didn't even know that he had his hand.
That's what she thought initially, and then she changed her mind.
Well,
based on things that happened afterwards, and said it wasn't an accident. Right? That was her testimony.
Well, that's accurate, but we look at this for the totality of the circumstances, and if I would urge the court to review the opening and closing again of the Commonwealth, because I believe that my reading of it is accurate, and I will stay with that for the moment. I will also say that the consent issue is somewhat misstated in the Commonwealth's brief, in that the consent that is withdrawn and referred to numerous times is consent to, for lack of a better term, an intimate relationship. At first she's like, "Oh, I'm getting a great tattoo and a lovely massage." And so he then says some things to her, and she says, "You know what? I don't want that. I just want a tattoo." And she stays on the table, and she stays on the table. And he continues to do the tattoo. And at the end...
But you don't, first of all, we don't have a picture of the tattoo, but I believe the Commonwealth says it was a 5 or 6 inch image on the woman's front and outer right thigh. Do you agree with that?
I have seen the tattoo. I don't know why it wasn't part of the record, or the picture of it, I should say. It's on the front and side, even if
But
you...
which side? Because that matters in this case. Is it on the outer right side?
Let's even say if it was outer, Your Honor.
Yep.
Tattoo ink splashes. Now, we don't have a tattoo expert on the record, and I don't know about any of the justices' familiarity with tattoos, and you don't need my
I
testimony
think we
about
can
tattoos.
say there is some familiarity among the panel about tattoos.
Okay, thank you. With that being said, ink does not stay where it's supposed to go throughout the working of a tattoo. It is not unreasonable to think that ink could have splashed on that same thigh. It's not as though he...
Part of the issue is we don't know how high up on the thigh the tattoo was. And I don't know whether that's in the record.
I don't recall either, but unless she's an extremely tall person, I'm not sure that that is, you know, it's not a stretch, no pun intended, that, you know, the ink could go up the thigh. Also, he's not saying any of the things that he said earlier. What he does when this offensive touching allegedly happens is he puts ink remover on a paper towel and then applies it to her thigh.
Right, but she told him no, and then he applied it to her leg.
That's accurate. We don't know the timing of it all, but also she doesn't just stay on the table.
Yeah, but women do that. I mean, that's because you can't believe it's happening to you, and so you want to believe that other people are good people, so you keep thinking, oh, this isn't happening, and then at some point you're like, oh, yes, this is happening. You know, this is 10 years I've been watching these cases, right? And so that is not a defense that's going to help you. At some point, she manages to say, no, don't touch me there, and he touches her. So why isn't that the end of the case?
Your Honor, I can't speak to the way all women behave, and I'm not going to win that argument in this courtroom at this time. I will mention 3 marriages, so I'm probably really ill equipped to handle this. But I will say that by a reasonable person's standard, she stays on the table, she pays him, she tips him. I understand, Your Honor, Your Honor doesn't like my argument, and I appreciate that. But I don't have years of studies of how women behave when they're potentially assaulted. I don't know. That's not part of the record in this case. All I have
Well, it's
is...
certainly in 10 years of our cases here, that I can tell you.
I appreciate that, Your Honor.
They cite, the Commonwealth relies on Commonwealth versus Cruz, which I think they characterize as saying, you know, there was no suggestive comments or propositions, and that changes what was happening here. What do you say to that?
Well, yeah, I use Cruz in my brief as well, but the inappropriate comments had stopped, and before this touching had happened. So what I would say is you have to look at the totality of the circumstances. Yes, there were comments early, but that had stopped, and what he was doing was finishing his job of giving her a tattoo. Yes, Your Honor.
Can we back up a bit? Because you're just challenging consent here, right? You're not challenging whether there was the intent requirement was satisfied. You're not challenging whether it was, you know, inadvertent or accidental. It's just about the victim's consent.
That's correct.
When anyone goes to a professional, a doctor, a dentist, a massage therapist, a tattoo artist, you go in with a defined scope of consent, that you are there to get this particular procedure, but you are not consenting to touchings that are not necessary for that procedure. So this is why I get confused when you talk about, well, the victim here didn't withdraw consent. Did she need to? She went in with a defined scope of consent. I will let you touch me for the purpose of administering this tattoo on my thigh, but not to other touchings. Isn't that enough for the jury to take from that to infer that there's a non-consent?
I understand what you're saying, Your Honor. A good tattoo artist shouldn't leave stray ink on a client that shouldn't be there, and he may not know what she's going to do to try to remove it. He's got to wrap the tattoo to finalize it. I'll just say, having had experience of sonograms, that are in certain areas. You consent to having someone put jelly on your body, and then they often hand you the towel yourself to clean the jelly off, but it is a much different process because no one's going to look at stray jelly on my body as I leave a medical center.
But again, the two touchings I think that are at issue here is one, the defendant putting his fingers on the victim's pubic area right at the start, and then second, the sexualized rubbing of the inner thigh to get the ostensibly to get the stray ink, right? Those are the two touchings that we're talking about.
Right,
and
she says
I guess
that...
couldn't the jury have sort of said she never consented to either of those touchings when she went in to get? She consented only those touchings that were necessary to apply the tattoo, and we can find that both those touchings fell outside the scope of what she had consented to.
I would disagree in the sense that an accidental touching is much like, the standard being on the tee and someone that sudden stop and touches an intimate part of your body. No one, we've all seen that sort of thing happening. If he is working on the tattoo and inadvertently puts his hand near her pubic area and she believes that he absolutely did it inadvertently, and I know later that may change, my reading of the record is that that is not a problem. Secondarily, the second part of your question, the inner thigh, she talks about him rubbing it sexually. And I honestly, at the risk of tremendous blowback, I don't know what that means. What I'm saying is I think that withdrawing her consent takes more than what happened here in this case. She had the opportunity, and I understand, Justice Henry, you disagree with me, but...
No, actually, I have an open mind, and I'll be pressing arguments to the Commonwealth.
Okay.
What I don't understand from your point of view is, let's assume that the first touching was inadvertent, and she accepts that he apologized and moved on, and the only touching we're talking about is the later one with removing the stray ink. But once she says no, and he does that anyway, I don't understand why you can succeed with your argument. And I want you to tell me why you can.
I honestly think that this is a timing issue, and also, I don't want to compare my client to a medical provider where something is happening and you say, oh no, I don't like that, and they're like, just a minute, we're going to finish up and then we'll be done. What we're doing here is really odd when you think about it, Your Honor. We are trying to take time and almost, to continue the terrible medical metaphor, creating a CAT scan or MRI and slicing, what is the time period? And it is hard to do that, I think, especially when you're dealing with, a criminal conviction, whether you wanted that conviction to rely on this testimony when you also need to, and the Commonwealth would agree, review the totality of the circumstances. That's the best answer I can give you, Your Honor. I am somewhat hamstrung by the fact that only the young lady testified. So I understand that's what we have. But I didn't get to try this case. I just get to be here today. Thank you. If there's no other questions, I will submit my brief and rely on it. Thank you very much.
Thank you very much.
Good morning, Your Honors, and may it please the Court. Jennifer Rose for the Commonwealth, asking that you affirm the defendant's conviction because the evidence viewed in the light most favorable to the Commonwealth was more than sufficient to establish the victim's lack of consent. With all due respect to my brother counsel, no reasonable person could say that a request for a tattoo on the victim's outer right front thigh was consent to touching her vagina, to sexually rubbing the inner part of her left thigh.
Well, but let's break it down for a minute. So he says that the first touching was not the alleged criminal act here. What do you say to that?
I would say that that was within the purview of the jury to determine whether that constituted an indecent touching or not. The jury was also able to see to see where the tattoo was on her thigh, as she demonstrated during her testimony, transcript page 68.
So there's two potentially allegedly indecent touchings here.
Correct.
The touching of the pubic area initially, and then the rubbing of the inner thigh later.
Correct.
Okay.
So on the second touching, it doesn't seem like she disputes that ink was in fact on her other thigh, sort of near the crease of the leg and the groin, right?
Correct.
And one could argue that a tattoo artist should clean up after themselves, right? And that a client would expect that.
That may well be within the job description of a tattoo artist. However, I would suggest that it does not provide him license to shove his hands in between a woman's thighs and sexually rub her thighs after she said no, that she would take care of it. She explicitly told him no, and he did it anyway.
So there wasn't any conversation that preceded the first touching, right? There was just, the procedure had started. So do you think that the jury could infer from the agreement that they had, the defendant and the victim, to get that the defendant would apply a tattoo on the victim, that they could infer from that itself that she had not consented to touchings unnecessary to getting a tattoo? Or did there need to be more evidence of her, saying, I don't want you to do this, I don't want you to do anything you don't need to?
I think, as Your Honor said earlier, the scope of consent was set by the parameters of the appointment, which was the application of the tattoo to her outer front right thigh, perhaps nearby areas that were necessary and appropriate for the placement of that tattoo. Viewed in the light most favorable to the Commonwealth, that most certainly did not include the victim's vagina, nor her inner left thigh, nor the sexual innuendos that were made while she sought a professional service at a business.
And that's because that's inherent in any kind of professional services agreement?
That's correct, Your
That
Honor.
you're involving a touching. So this is the same principle that would apply to a medical appointment, a dental appointment, a massage, something like that?
That's correct, Your Honor.
But what if we change the fact a little here and however it happened, the ink did get on the left thigh, and assume she didn't say, don't touch me there, then wouldn't it be in the scope of the tattoo artist's job to clean that up? Because I can imagine if they didn't, and she was wearing clothes to leave, which presumably she was, and they got stained with ink, then you might have an unhappy client.
Sure, absolutely. Upon those facts, it might be within the scope of his job. However, the victim here explicitly said no, and viewed in the light most favorable to the Commonwealth, again, I don't believe that her request for the tattoo constituted consent to touch her inner left thigh. She described it as the crease between her thigh and her pubic area. The court has no further questions. The Commonwealth would rest on its brief.
Great, thank you very
Delightful.
much.
Thank
We
you, Your Honors.
Understand your arguments. With that, we'll take our morning break.
Ms. Rose, nice to meet you.
Take care.
You too.
Resuming the March 2nd, 2026 sitting. Case number 4 today is 2025 P-749, Department and Families and another versus Mother. I understand there's a time split today on the appellee side of 9 minutes for the department and 6 minutes for the child. I want to remind everyone that the matter is impounded, so please, parent, just use parent, mother, father, child, and try not to use anybody's name. And with that, we'll hear from attorney for the mother.
Good morning, Your Honors. I'm Margaret Gary, represent the mother. I should say at the outset that since I know there have been a number of these cases that have come before this court and the SJC recently, and the juvenile court has changed its protocol, and the trial court judges now go through a checklist at the 72.
I was wondering if anybody had a checklist.
Somebody has figured out that that's a good idea.
Great.
Now, if everybody continues to do it, we'll be all set. But I've had any number of cases where once it comes in the 72-hour hearing where I know there's a jurisdictional issue, but some part of me, I want to finish it up. Judges and lawyers are very sticky people. And we just want to keep what we started and finish it. And sometimes you can get it dismissed and there's no problem. And other times you end up with a situation like this. That apparently nobody noticed until the case had been submitted for the judge to write findings.
Well,
and now
this case is a little different, though. I mean, first, just to make life a little clearer, the mother first raised, and I know she can, but the mother, am I right, the mother first raised the jurisdictional issue after trial and a motion for relief from judgment?
Well, the judge put it in her findings.
Right, but did anybody argue it up until the judge put it in the findings?
No, it was
Okay.
never, I didn't see it
Right,
anywhere.
everybody needs a checklist, I would say, including the Parents' Council.
Mother waived her 72-hour hearing, so there was
Okay.
probably no opportunity. And it was COVID time, so probably it was done remotely, and then nobody thought to ask.
They argue, and I guess I'll ask you, could any state other than Massachusetts have had jurisdiction under paragraphs 1, 2, and 3? I know that's compound, we can take them one at a time. Did any state have jurisdiction other than Massachusetts under paragraph 1?
Your Honor, you'll have to forgive me. 1, 2, and 3. I have never been able to keep that statute straight in my head. I will say it's New Hampshire because for whatever the statute says, that's where Mother was living, and it's not a home state.
Well, 1 is home state jurisdiction,
It's not that.
right, default jurisdiction. That's 2.
Not that.
3 is emergency jurisdiction.
Yes, well, the court did have emergency jurisdiction.
Our court, Massachusetts did, but did any other state have emergency jurisdiction?
I imagine New Hampshire would have.
How? The baby wasn't there.
Well, if the statute requires him to be in the state, then Massachusetts would have had it. He
Okay.
could have, of course, sometimes children are moved. He was in the process of being moved at the time the case began. So it could be that he could have ended up back in New Hampshire, and New Hampshire could have filed. I mean, there was nothing going on with him that required him to remain in the Commonwealth.
So one of the differences, maybe, between you, is, you tell me, is when are we considering whether jurisdiction exists? I was surprised that the department seems to be saying that we don't have to consider it at the outset of the case. Are you saying we'd consider it at the outset of the case, or are you saying that the court should consider later evolving facts?
If it's an evolving fact, then the court can acquire jurisdiction after the fact.
Right.
So we can't do that because
So
all
you
the
say
case law
it's
says we can't do that. I think at the 72-hour hearing, I don't think they would have moved the child at the 72-hour hearing. It's just not practical. But at the end of the 72-hour hearing, we should have said, where's mom living? All the evidence that they considered when the case came in, to the extent anything was considered, was stuff that Mother had with her up in New Hampshire.
I couldn't tell this. Does the record indicate the exact date that the mother arrived in New Hampshire?
No, the judge's findings say 2 months. I know that one of my learned colleagues says it was only 1 month, but it was between 1 month and 2 months, I guess we can agree. But I went with the findings. She had been up in the shelter for quite a while because the people seemed to know her pretty well. They knew the child well. They were able to give descriptions of how they were doing.
So
the department
the child
inquired.
argues that the mother brought the child to Massachusetts to reside with a former romantic partner. Do you agree with that or
No.
disagree with that?
No, there's nothing in the record to indicate that.
All right.
I think what's in the record is that she wanted a break. She was up in New Hampshire, she wanted a break, so she went down to East Longmeadow, and, you know, it may have ultimately evolved that she ended up in Massachusetts, but I don't think it did. In fact, you know, within, say, 12 to 18 hours, she was overdosing and on her way to Bay State. And in that sense, it's exactly the same as Twyla, where there's dad standing in the 7-Eleven, the police come in and arrest him. That's the same level of context that the child has with this state.
Well, so, I mean, let's talk about that for a minute, because the Commonwealth is saying, first, mom visited here, and I really don't mean in any way to be insensitive, but mom made a suicide attempt here, meaning mom wasn't leaving New Hampshire, or leaving Massachusetts intentionally at that point. And that before the suicide attempt, she'd asked her stepmother, who lived in Massachusetts, to take the child for a period. And she said, I'm just putting their best case, and I'll put your best case to them.
Sure.
That after the overdose, mom said she had hoped to move to Massachusetts, and she chose the stepmother who lived in Massachusetts as a care provider. I think that's their best case. They can tell me if I've missed any facts.
That is correct, and the department would say that that was an inappropriate care provider, and there was no way
Why,
that that would
yes.
interfere. But that's part A. Part B, I think I ascertained and cited to the record that she was full of fentanyl when she said she wanted to stay. She also said that she wanted to go back to New Hampshire where her supports were, and that's where she went the minute she was discharged from the hospital. So I think according to Farage, we have to look at what people do, not what people say.
So did the record establish whether there were any pediatric records for the child in New Hampshire?
Yes, there were two sets. There was a set from Ohio and a set from Florida. This is a record where everything's all over the
What about from New Hampshire?
There weren't any in New Hampshire yet. That's why I would have liked an opportunity to present some evidence on that, because if she had made an application for New Hampshire, Medicaid, whatever they call it, what kind of applications were in, what type of, you know, activity had she engaged in with the child. I think it's fair to say that based on the records, the pediatric records, and the fact that the child was up to date when he came into care, that she probably would have taken care of that sooner as opposed to later. And it would be great if she'd moved to Massachusetts, because if she was sitting in Springfield, we wouldn't have all of the other issues that had plagued this case about, you know, getting down from Nashua into Springfield once a week on 4 or
Right,
5
so I
buses.
understand your argument about we look at the outset of the case and that your client can raise jurisdiction at any time, but do you have a case that says that if they do raise it as late as it was raised here, they get to put in new facts, or are they stuck with the factual record we have?
I don't have any cases with that. I know that whether there's jurisdiction or not is a question of law, but it's a question of law as applied to facts. And if it never came up, the judge is essentially looking at a record where nobody was targeting their argument or their presentations to that particular issue. And therefore, there isn't a record on that.
Was there a request before the trial judge to introduce jurisdictional evidence?
There was, I asked her in the Rule 60 motion.
You,
Now, I
right, you
understand-
asked for relief under Rule 60. but
Right, I
did you
understand
ask
that
to
could
sort
be
of say, I want a
denied.
hearing, I want to put on witnesses, I want to introduce
I
evidence?
did say that.
You did say that?
I did say that, but I understand that the judge has discretion to deny my motion without a hearing, but I did request it.
But you did request to submit evidence? Is that, or
I
as you-
requested
or making the
permission to
motion?
submit evidence. I did not, in retrospect, it would have been great if I'd gotten an affidavit from the mother saying X, Y, and Z, because then that would be in the record. But my request is in the court documents appendix that I submitted towards the end. So it would be there. And I'm mindful of the fact that the real suffering here is the child, because he had, from what's in the record, he had a good relationship with his mom, and they were close. And the foster parents have had him now for coming up on 5 years. And it's unfortunate that if there is a jurisdictional problem here that it's going to have to be undone. And, well,
So, but this case is unusual, though, on the jurisdictional side, because if we are looking at the moment the case is brought, she'd had 8, tell me if I got this wrong, but they say that she'd had 8 interstate moves prior to going to New Hampshire, that she didn't stay anywhere for more than 6 months, right?
right, well, but then when you look at the findings, it says, the judge says, I could not have predicted when the case came in that the mother would have stayed settled in New Hampshire. Likewise, how could we have predicted when the case came in that the child was going to be in Massachusetts for the next 4 or 5 years? We couldn't. We don't know what's going to happen at the outset of the case. That's why you look at the contacts. I agree, no home state. Mother was very transient. She had come into New Hampshire. She was settling down. She had people that were interviewed by the court, by the 51B investigator who knew her fairly well.
Who were the relatives that she had in New Hampshire?
I think there was Migdalia, someone. There was a relative in around the Lowell area that the department didn't like, and she had somebody else up in the Nashua area. And I think she has said she had a couple of people up there. I know she had lived there in the past. Her only criminal record is from the Nashua area. She apparently ate somewhere without paying. That's the extent of her criminal record.
Right. So are you making a forum nonconvenience argument?
No, I can't, because it's waived if I don't make it. That was put in there for the equities of it, just to say that, it should have come out some other way. It should have been more convenient for the mother. I mean, all of what we're supposed to do in these cases is to do things to reunify the family, not see how far we can separate them. It kind of what the judge was saying kind of reminded me of, Cinderella picking lentils out of the grate, well, you should have been able to budget your $900 a month to afford, $400 for room and $100 for a round-trip bus. No, that wasn't her burden. It was the department's burden to do that. And I'm surprised. It was a very zealously presented case on the part of the child. I'm surprised that there wasn't more of that zeal directed toward, getting mother the services and accommodations she was entitled to. But again, if I have a structural error, I'm not going to be arguing ineffective assistance, because that really doesn't get me anywhere on these facts.
Are you arguing due process?
I'm arguing due process as to the Rule 60 motion. I'm arguing structural error as to the rest of the case, because there wasn't any contacts with Massachusetts. I mean, when I looked at all of the other cases, it's just happenstance that she was there. She could have been in Vermont and overdosed in Vermont, and we'd be saying, oh, well, in that case, Vermont has the contacts. If someone was in a car accident in Massachusetts, and I say that suddenly remembering that we have done this. If there's a car accident in Massachusetts and the parents are both in the hospital, does the court have emergency jurisdiction? Sure they do. But are we going to keep the case in Massachusetts if the parents are just passing through? No. I think part of it is saying, well, she's an addict and she's got a bad record, and we're just going to assume that she's going to keep right on doing what she's doing. But if you look at other quote, unquote, more innocent reasons for being in the Commonwealth, I don't think we would be pressing to keep the child here where the family had contacts elsewhere. A child's home, and aside from the statute, a child's home is with his parent. So and if his parent was in New Hampshire, it certainly wouldn't have hurt anybody to send the case up there at the beginning, and it should have happened, and it's unfortunate that it didn't happen. And I'll rest on my brief.
Well, so you asked that we vacate the rulings only as to the mother, and I understand the father's stipulated determination of parental rights, but if we didn't have jurisdiction, then how could we not?
Well, I invited father's counsel to put her oar into this, and she did not. So I can't comment on what he would or would not want. His criminal record is manifest.
Well, I'm not asking what he does or doesn't want, but if we didn't have jurisdiction, I don't see how we wouldn't also
He had jurisdiction right through the 72-hour hearing, had emergency jurisdiction. So it will roll back till then. And I speculated at the end of my presentation of what is going to happen. what's going to happen is if it gets offered to New Hampshire, New Hampshire's going to say, gosh, they might not, but more likely they will just say, oh, gosh, you know, all the evidence is in Massachusetts now. Maybe it's better that you just handle it. But still, that's not a great reason for not doing what's required given the jurisdictional situation here.
Thank you very much. We understand your argument, very well presented. We'll hear from the department. As I said, there's a split of 9 minutes and 6 minutes.
Good morning, Your Honors. William Cuddle for the department. Judge Henry, can you let me know when I have approximately 1 minute left if I'm getting close?
Yes.
The department's asking, as you are well aware, to find that there was jurisdiction in this case and that the court's decree should be affirmed for this child. I'm here to answer questions for you. If you have questions, I can clarify a couple of points up front. First of all, the court found and mother conceded that no state had home state jurisdiction under subsection 1. I'm going to call it the Jurisdiction Act instead of Massachusetts Child Custody Jurisdiction Act. It's a lot to say. But under section 1, mother lived a very transient life, as the court found. Massachusetts wasn't the home state.
But I want to drill down more specifically about whether or not we are looking at the facts at basically at the 72-hour hearing or at the time the child went into DCF care. Or are we looking at the facts as they evolve? And the only exception is Anissa says we look at whether the other state declined jurisdiction, but it seems like you're pushing Anissa pretty hard to read it past that one particular fact.
Which fact, Your Honor?
Whether the other state that's a potential candidate for asserting jurisdiction has declined jurisdiction. That can only happen after the child is in care.
No, but there's no facts, there's no state, there's no issue of declining jurisdiction in this case.
Right, but you're saying, well, I know what you said in your brief. I don't know what you're saying here. Are we limited to looking at the facts at the time that the child went into DCF care? Because I understood your brief to say, no, we can look at facts later.
You can look at facts later, but if you look at the Anisha case, I think that's how you pronounce it, 2016, Judge Lyman in that case, the trial judge, he took time. There was another state involved with custody in that case, and he didn't make any custody orders. He took time to communicate with the other state, and that's what the Jurisdiction Act is. Part of it, why it exists, is for the communication between different states, so there's not competition or miscommunication between states. In that case, he waited a significant amount of time before establishing the ultimate jurisdiction.
But in what I'm asking, though, Anissa definitely says later you can look at whether the other state declined jurisdiction, but I didn't see that Anissa used any other fact after the child came into care. And that's the question I'm asking you. In terms of the underlying facts about the child and the parent, are we looking only at the time the child goes into care with the department?
Well, that's the beginning point when jurisdiction is considered, especially under subsection 2, default jurisdiction, and subsection 4, which is what the court relied on here, the appropriate forum jurisdiction. Because at the time that the child, the department entered the custody order on, I think it was March 11th or 10th, the child was in Massachusetts with the mother. The court, and just to clarify before I lose this thought, Your Honor, the findings do show that mother got picked up from her shelter in New Hampshire, which she entered on February 17th. She got picked up by her girlfriend. I think her name is Alyssa.
We're not using anybody's names.
I'm sorry, Your Honor,
but
picked up by the girlfriend, brought back to Massachusetts, I think to East Longmeadow in Massachusetts. That's where the mother had her difficulties. That's where the child was, actually at that point, the child was given back to the stepmother who lived in Lowell, Massachusetts. And these are all part of the significant contacts that the court has to consider in the best interest.
Right, but let's back up. Once a child comes into care, what's the department's obligation, right? The department's supposed to see if it can unify the family, correct?
Yes.
And is that like the paramount, safely reunify the family? Is that
Yes, and in this case, if you noticed, because I did, I took great pause in noticing, unlike most of the cases, the department was seeking reunification for a very long time in this case. The child is the party that moved for termination, not the department.
Yes, so the facts are definitely unusual in that way, but one could argue that once the mother went back to New Hampshire and the child was here in Massachusetts, that the die was cast, that particularly once the child was nowhere near New Hampshire and was in the middle of the state.
Well, in terms of the jurisdictional analysis, the jurisdictional analysis doesn't concern itself with those factors afterwards, Your Honor.
Why not? If the
because-
goal
because-
is reunification, if that's what we're all supposed to be at least striving or pretending to be striving for, then how was there ever a chance that a person who was in New Hampshire with no transportation available other than public transportation is going to be able to reunite with a child that's in the Springfield area?
Because under the statute, all parties and courts are guided by what the limits of the subsections are. And in the case, when the court has to consider, like as in this case, when we're looking at the fourth subsection of the statute, the court has to do a best interest analysis. And that consists of significant contacts between a parent and the child and significant evidence of what's in the child's present and future interests going forward.
Can we consider the stepmother who DCF said was not appropriate as a placement? Is that a factor that weighs in favor of Massachusetts?
That's one factor. The factors that weigh in favor of Massachusetts, our mother was in Massachusetts, the child was in Massachusetts.
But she argues that was happenstance. She could have been in any
It's
one of the
not-
50 states.
Your Honor, it's not happenstance, it's the facts of the case.
Right, but she could have called a friend in Ohio. She could have called a friend in
Your Honor,
Vermont.
I understand what you're saying. It could also be,
Called the father in Connecticut.
under your analysis, respectfully, anything the mother says about New Hampshire is speculation too. Because there's no information of mother doing anything in New Hampshire. She had no pediatrician for the child. That's in
Well, she
finding
was in a shelter that might have provided her some services.
There's no evidence of any services. The mother first said to the 51B investigator that.
So this is why I don't understand why you're saying we should consider facts afterwards, because if the goal is reunification.
I don't know, Your Honor, when you say fact afterwards, I'm getting confused. I don't know what you mean.
In your brief, you say that we can consider facts that occur after the child went into care with the department. And you don't limit it just to whether or not the other state declines jurisdiction. You make a general statement, I think, that we can consider other facts. And you want to rely on the fact that the child's here and he starts getting records.
The factors that we say are part of the analysis under the best interest standard, which is twofold. Significant contacts, which we explain in our brief, are the primary facts that no one can dispute. And before I even get into there's not a lot of facts in this case because mother was transient, okay?
Right,
we all know that.
But within 6 months of this case existing, mother was still in New Hampshire, and it's not, I mean, at certain times it can be very hard to get a pediatrician, but generally speaking, you can get a pediatrician when you need a pediatrician. So at that point, if the goal is reunification, then the only way that was going to happen is if the child was in the same state as the mother or the mother was in the same state as the child. Now, maybe she made a poor choice and she should have moved to Massachusetts, but she had some sort of support system in New Hampshire, and we could have at that point given the child to New Hampshire, and the child's interests would have been protected, and there would have been a chance at reunification.
There was an IC, Your Honor, if you want to go off the jurisdiction issue, I'll do that. But
no, I'm still talking about your brief says, I mean, I can go,
Your Honor.
And I didn't give you your minute warning, so I'm giving you your minute warning now.
I need more than a minute because you're not letting me finish my analysis for you. You're asking me questions and I'd like to answer your question. To answer your question, what we're saying in our brief is that under the standard of the statute, the court has to look at not only the significant contacts, but the substantial evidence of care, protection, training, and contacts for the child now and in the future. That's why we say all that other evidence, because that's important. That's how you figure out the best interests of the child.
Right.
It wasn't just a
your...
discretionary, I'm sorry, Your Honor, it wasn't just a discretionary act that we were doing. We were following the statute and the analysis. The analysis is very complicated, I grant you that, but it has to be followed.
But the child is basically existing and living, and the issue with reunification is whether the parent is doing what the parent needs to be able to care for the child. And all of those facts will always be in the other state, and were, in fact, in this case, in a different state.
Did you say the child is existing and living?
In Massachusetts.
Right, and the mother had a service plan in Massachusetts. She had social workers to work with people in Massachusetts. The court found in terms of her fitness, she didn't, unfortunately, she didn't meet her parental goals and benefit from services. She was still struggling with her substance abuse issues. The court made all those findings.
So what's your best case for the connections to Massachusetts, other than the child being in Massachusetts?
Yeah, Anisha. I'll rely on Anisha. The court relied on Anisha. Judge Lyman, the trial judge, found the contacts, and he actually said that one of the indicia of factors he considered was the mother's intention to bring the child to the hospital the next day for a pediatric appointment, and she didn't even end up going. But that was still a factor. It wasn't a dispositive factor.
Right, I'm asking what the facts were in this case. The ties to Massachusetts were that the child was here. Mother brought the child into Massachusetts, and mother apparently at some point decided they were leaving Massachusetts by way of suicide. Again, I don't mean to be insensitive.
Right.
Leaving the child here, and then there would definitely not be New Hampshire jurisdiction.
Here, okay.
What other facts are there in this case?
The other facts in this case are that mother reached out to her stepmother before she left the shelter and asked her stepmother to take care of her child because she couldn't do it anymore, and she was living, and the stepmother was living in Lowell. Mother came to Massachusetts, and we all know what happened. Mother received treatment in Massachusetts. The child was placed in care in Massachusetts. The department did an investigation of the child to find out what the child's needs were that no one knew about other than Massachusetts, and that is what the court relied on in finding that there were significant contacts and the best interest of the child was met for jurisdictional purposes. If you have no further questions, I'll rely on the brief.
I see no further questions, so we will hear for counsel for the child.
Good morning, Your Honors. Daniel Katz for the child. Although Your Honors have mentioned that reunification is a goal that the department looks to achieve, we must remember that the overarching goal of all of these types of cases is the best interest of the child. And in that sense, I would be remiss in not putting forth his position in terms of the substance issues of this case. First, we look at domestic violence, which the courts, and of course we all agree, is both physically...
We understand what the facts are as to the problems with the parenting that was happening, but this is a jurisdictional question. What are the ties to Massachusetts? What are the ties to New Hampshire?
So the ties are that, to Massachusetts, are that the child was living since March 21 with a couple in Massachusetts. He was receiving pediatric care in Massachusetts. He was also receiving therapy in Massachusetts. And finally, he was going to school.
Okay, if the child had been in New Hampshire for 6 months prior to being brought into Massachusetts, would you agree there would not be jurisdiction here under the statute?
If you can get jurisdiction under home state, and the child had been in New Hampshire for 6 months, Your Honor, yes. but that wasn't the case here. And the mother's intention, while it can't be a dispositive factor, because what we learned from Farij, I might be mispronouncing that case, my apologies, is that you can't just intend home state jurisdiction, but that's different from here. She was intending to possibly leave the child in the care of this stepmother who happened to be in Massachusetts, although at the time was away in New Jersey. So the ties are to Massachusetts. There is no home state in any state. And we know that because we look at the peripatetic nature of the mother, the unfortunate, well, it seems to be unfortunate that she was moving all this time, and no evidence that the mother, back to an intention, intended to look for daycare in New Hampshire, or no intention that the mother intended to find a pediatrician for the child. Your Honor mentioned that there might have been resources in New Hampshire, but there's no evidence. There's only evidence that she was at this domestic violence shelter and then called her then girlfriend or friend.
Just, what do you think are the chances that reunification is going to occur if the child is in Massachusetts and the parent is in another state without a car? There's zero.
There is zero depending on...
Even if she got herself
She did
together.
reject... Sorry, Your Honor.
Go ahead.
Oh, she rejected, help with bus fare and transportation. So the department was trying to facilitate that, and that goes under the reunification issue. But the overarching concern in these cases is always the best interest of the child. And yes, I know we're talking about jurisdiction here, but everything points to no home state jurisdiction. So then we have to look to the other three subsections of the Act, and the appropriate forum jurisdiction is what the motion judge correctly identified as appropriate, that Massachusetts was in the best interest, it was in the best interest of the child that Massachusetts had jurisdiction, and that best interest is that two-part test, right, in terms of significant contacts, and then also evidence in terms of the future or the present needs of the child. And the fact that the child was going to school here, had a pediatrician here, was doing individual therapy here, that allowed the judge to look under the best interest question and say, oh yes, Massachusetts is the appropriate forum.
So the department argues on page 43 of its brief that contrary to the mother's assertion that the MCCJA implicitly requires that jurisdiction be established at the outset of the case, and then cites Anisha for the proposition we could consider other information. And in that case, it involved the other state declining jurisdiction. When do you think we look at jurisdiction?
Well, ideally jurisdiction is done from the get-go. I know that wasn't done here, which of course is unfortunate, and it makes your job more difficult, Your Honors. But the statute itself, in its rule in appropriate forum jurisdiction in subsection 4 and also in subsection 2 default jurisdiction, it has that best interest requirement. And in that requirement, in the two subsections of that, you have to look at evidence that's the most current as well. And that led the judge correctly, in our opinion, that Massachusetts was an appropriate forum, not a home state. And you're right, if the child had been living for 6 months, or even even 6 months with some absences in that time period, then New Hampshire would have been. But there's no tie to New Hampshire except she was picked up from that a domestic violence shelter. If there's anything else.
Seeing none, well argued. I think we understand everyone's positions, and the case is submitted. We'll hear our fifth and final case today, as one case was submitted on the papers, and that's 2024 P918, PRI Glen Grove, LLC versus ELAINE Laughen.
Thank you.
Members of the panel, may it please the court. My name is Alex Van Dyke, and I represent Ms. Laughen. The Housing Court's order denying Ms. Laughen's reasonable accommodation defense should be reversed and remanded either with instructions for the defense to be granted or for reconsideration under the correct legal standard. Ms. Laughen made a modest request. Because of acute attacks of her progressive multiple sclerosis in 2023 that left her bedridden and that severely affected her emotions and cognitive abilities, she needed to be excused for submitting a late HUD recertification form and for sending PRI emotionally charged emails about conditions in her apartment that exacerbated her multiple sclerosis.
So one of the obvious questions at the beginning of this case is, can a person, in this case a tenant, contract themselves into an obligation to do certain things, even if in the absence of that contract, they could ask for reasonable accommodations? And I'll just put a finer point on it here. The conditions were the same, although I understand her disease may have progressed, right?
I disagree with that, Your Honor. The
Okay.
disease
No,
progressed,
I'm asking
but
the question, what your answer is.
yes, absolutely. In 2023, there was a very specific acute attack that Ms. Laughen testified to at the hearing, and that's what we're dealing with here, is the effects of that 2023 attack and what that caused for her. So,
I didn't read her testimony to be saying that acute attack was related to the emails, but rather only to her inability to submit the documents for the recertification.
I think it was directly related to the emails, Your Honor, and I'll call that out for a moment. So one of the things Ms. Laughen testified to was that the 2023 attack significantly affected her emotions, and I think as PRI explained quite extensively, the emails we're dealing with here are emotionally charged. So I think that's a direct connection between the attack and the emails. Another one is that it affected her cognitive abilities. It made it a little more difficult to comply with the 2021 agreement's requirement that she use a third party. And finally, I would note that the emails that we're dealing with here all relate to conditions in the apartment that exacerbated her MS.
Can you explain why her condition made it a reasonable accommodation to communicate directly with them as opposed to a third party? I didn't follow the logic of that.
Yes, Your Honor. I think I might repeat a little bit of what I just said, but I can try and do so a little bit differently. So she noted a few things that the 2023 attack did. The first one was it affected her emotions. The emails that we're dealing with here, as PRI explained, are emotionally charged. So that is one clear link. I think another clear link is that it affected her cognitive abilities. So it made it difficult for her to use a third party as the 2021 agreement contemplated. She was not able to think as clearly about how she was communicating with PRI. And the final one is that the 2023 attack made it more important for her to communicate with PRI about conditions in the apartment that exacerbated her MS, which is what these emails were doing.
What was the third party that she was supposed to use, or what was available to her?
In theory, it could have been an attorney. I think that is most likely what the parties had in mind.
And did she not have an attorney relationship at a certain point, or is that not the issue?
I'm not sure that that's clear in the record exactly, when she was represented during this time period.
Can I just ask a factual question? What's the impact of Ms. Laughlin's failure to complete her 2022-2023 recertifications? What difference did that make?
What difference did it make to PRI?
To anyone.
So I think that if the recertifications were not done, there is a possibility that PRI could lose a subsidy. However, I think it's important that I don't believe PRI asserted or proved here that they in fact lost a subsidy.
Well, that's my question. Did anyone lose a subsidy? Was there actually a cost paid? Was there a financial cost imposed as a result of that, or was this just a technical violation that didn't make a difference in the end?
I don't believe that PRI established at the hearing that there was actually any cost to them. HUD, I believe, accepts late forms, which is what Ms. Laughen ended up submitting here was a late form. So I think the answer to your question is that there was not a end-of-the-day cost other than a possible slight administrative burden in getting the form late.
So in your brief, you say it is irrelevant that your client did not put forth any new or additional reasons for her accommodation request. And I took that to be saying that in fact there were no new reasons, and I hear you today to be saying something different. So could you clarify?
I think, Your Honor, yes, I'm happy to clarify. I think what I meant there is that the MS was the same disability in 2021 and 2023 generally, which I think is what the Housing Court was noting when it talked about new conditions. I don't mean that there was truly no difference between Ms. Laughen's state.
Would you agree if there truly were no difference, that she would not be entitled to an accommodation?
I don't believe that's the case, Your Honor, because I think that it's possible that what they agreed to in 2021 might have been a reasonable accommodation at that time.
There's no changed circumstance. The same, everything is the same. And she continues to send the emails. And you're saying every single time she gets an accommodation? How many times does your client have to breach the agreement in order for the landlord to get judgment under the agreement?
Understood, Your Honor. I think it is possible that the parties could agree that something might be a reasonable accommodation. They do it for a little bit, and it turns out that, in fact, it was not a reasonable accommodation after it's attempted. I think that's possible. I want to make clear, though, that there was a significant change here because of the 2023 attacks, so I don't think we're in that factual scenario. And then to Your Honor's second question about whether the fact that maybe this is a repeat that there's a repetition of emails going directly to PRI, I want to be very clear that we're dealing here just with the first accommodation request based on direct emails to PRI, because that was set out in the 2021 agreement. Then at the hearing, this is the first time that there's been a request.
So the second time the landlord gets judgment?
I'm sorry, Your Honor?
If it happens again, then the second time the landlord gets judgment?
No, I don't think that would be true. I think perhaps that could be a factor that could be considered on the reasonableness element and whether or not there is an undue burden on the landlord. I don't think it would be an automatic.
And what incentive does the landlord have to enter into the agreement?
What incentive does the landlord, did PRI have to enter into?
The landlord just generally, if they bring a summary process action and they go into mediation and the tenants ask for some sort of accommodation, they grant it, but I hear you to be saying that the tenant can breach the agreement repeatedly and ask for the same accommodation every time. So what incentive would a landlord have to enter into the agreement?
Understood. I want to be very clear. I'm not suggesting that if a reasonable accommodation is granted and it is in fact a sufficient reasonable accommodation, then tenants can simply breach. I'm not suggesting that. But in 2021, PRI had an obligation, a legal obligation, to grant reasonable accommodations, and it had the exact same obligation in 2023. Ms. LaFfaN doesn't, and no tenant has a right to breach. They do have a right to seek reasonable accommodations, which is what Ms. Laughen's doing here.
But the agreement says, putting aside maybe the acute episode in 2023, the agreement says this agreement addresses all reasonable accommodation requests to date. So if there's no change in circumstance, which I think is what the judge was saying, why isn't the agreement binding?
Your Honor, I'll happy to answer this, but then I do definitely want to make sure I get to explaining that I don't think the judge said that, nor is that the actual facts of this case because of the 2023 attacks. As to the answer, I think it's just that it's possible the reasonable accommodations, after they're implemented, may not in fact be sufficient to accommodate a tenant with a disability as the parties thought at the time. That being said, I want to be very clear that I think the 2023 attack is critical here.
Okay, I understand that, but I don't mean to cut you. I just don't want you to leave this point. So let me ask you a hypothetical. So let's say a tenant's lease says no animals allowed in the unit, and the tenant keeps multiple animals. It becomes a health issue for the neighbors and the tenant herself. So the landlord brings a summary process action. They go into mediation. The tenant says, I need an accommodation because I have a disability that requires me to have an emotional support animal. So they agree that she can keep one animal. The agreement says this addresses all reasonable accommodations, okay? So then a few months later, she acquires more animals, and then she comes in saying, oh, actually, my disability, the same one, requires me to have 3 emotional support animals. Would the landlord be entitled to judgment then or not?
I think that if the tenant can prove that their disability requires or has a causal link, has a nexus with the conduct at issue, and that new request still does not impose an undue burden, I do think she would be entitled to that.
So the agreement doesn't matter at all? even though it was signed, negotiated by attorneys, and approved by the judge?
I think the agreement matters, but it doesn't override fair housing law's requirements for all reasonable accommodations to be granted as
It does
as they
seem
arise.
like your position really creates some bad incentives. Like why, if an agreement doesn't really involving reasonable accommodations doesn't actually mean anything in practice, what incentive does a landlord have to work out its dispute with the tenant and not just charge for, and try to seek possession in a summary process action? Like what, you're taking away this kind of tool of resolving disputes because you're essentially saying the tenant is never bound. And that's the problem here.
Your Honor, I really don't mean to say that a tenant is not bound by the agreement. It's simply that if they later request a reasonable accommodation and their request meets all of the legal requirements for a reasonable accommodation, they're entitled to it.
Wouldn't there have to be at least some changed circumstances? I'm sorry.
No, well,
Understood.
factually, I mean, specifically in this case, the landlord argues the housing court asked her how any of her conditions that she had told the court about, including the, I don't want to say her medical condition if we haven't already, caused her to send or not send these emotionally charged emails, and they say her answer was one word, emotion, and that isn't enough. So what do you say to that?
I disagree strongly on the facts there, Your Honor. I think on appendix pages 60 to 63, she walks through a number of circumstances. I've talked about them briefly a couple of times, but I'm happy to run through them again. As to the HUD forms, there were physical impediments. She was bedridden.
I don't think we're worried about the HUD forms.
Understood, so I'll stick with the emails. And this is a similar answer I think I gave to Your Honor and Justice Shin earlier, that there was emotions were affected, emotionally charged emails. Cognition was affected. It made it hard to comply with the 2021 agreement. And that the needs of her MS were were heightened during this 2023 attack. And so I think, Your Honors, to be clear about something, how important this 2023 attack was, all of the questions we've dealt with this morning about the incentives for a landlord to enter an agreement and whether a tenant is bound, I don't think the court needs to address whether, if there's no changed circumstances at all, a tenant can seek a further reasonable accommodation, because I think in this case, the reasonable accommodation was sought based on the 2023 attacks.
Well, I'm sorry, go ahead.
Can you tell us how we can draw a reasonable line between the tenant genuinely needing an accommodation and the tenant just being difficult? Because I don't see how we're drawing that line.
Your Honor,
I don't get it, why she has to, there may not be a third party, and maybe, in which case that fact needed to be in here, and she may not be able to go, because the attorney had withdrawn, I believe. So if she needed to go get a third party and she couldn't, because she's isolated, doesn't have enough friends, and doesn't have an attorney, that would make sense to me. But otherwise, what's the line? Because a lot of words, very hurtful words, have been said after someone said, I just needed to tell the truth, or I was upset and I needed to speak my piece. And they say terrible, hurtful things. So what's the line here about her genuinely needing to email them directly, and that she could have just emailed, she just needed to send an email, she could have sent an email to some third party who could then interface with the landlord?
So, Your Honor, I think one answer is on the standard. You've mentioned genuinely need, but I think the standard that's required is simply a causal link or a nexus. And that's what's required. If she can establish that the conduct at issue, the sending of emails, was caused by her disability, then she can't be evicted for that conduct, because that's unlawful discrimination. So she simply has to show that the conduct at issue was caused.
But that's where this is the hardest case for you, because she needed to be able to email someone. And I don't get why the third party was not a valid option, where they could have screened out all the emotion and put forward her, let's assume she was incapable of stripping out the emotional charge, right? But the third party could have done that and gone to the landlord.
Your Honor, I think, though, the question is not whether she was simply incapable of stripping out the emotional nature of the emails. It's whether the 2023 attack and the emotional and cognitive and physical effects of it caused her to send them directly versus a third party. So it's not just the emotions, it's actually the fact that she wasn't using a third party was caused by the 2023 attacks.
The judge found the defendant has not offered any new or additional reasons for her reasonable accommodation request other than what she appears to have previously raised. Isn't that a factual finding that we have to accept absent clear error?
Your Honor, I think what the judge was saying there, and I see my time's up, may I finish this? I think what the judge was saying there was simply that the multiple sclerosis was the same in 2021 and 2023. If what the judge was saying instead was that there were truly nothing new, I think that would be clear error. To be clear, though, I'm not suggesting the court needs to say that. It just needs to read that sentence to mean that the multiple sclerosis was the root disability or the root disease or ailment in 2021 and 2023. And also on this point, we haven't addressed that I think the only reason the housing court rejected a nexus was that there was no medical documentation, which I don't think is a valid reason for rejecting a tenant's testimony as to causation.
So I want to ask you a hypothetical that is not this case, okay?
Understood, Your Honor.
But is harder, right? And because it's been in the news, it seems like an easy example to pick. And again, I don't mean to offend anybody, but you have this person with Tourette's who sometimes says something racist. Let's assume that the landlord has office staff that are all people of color. And so they enter into a contract that says that the tenant will communicate requests through a third party because the tenant is going to say racist stuff, and there's no reason for the people of color in that office to put up with that, okay? Let's assume it's totally not the tenant's fault, but you have two different needs here, okay? And then she says, I didn't communicate through a third party because I'm upset, or because I really don't understand the third party part, but how do we draw that line? Because those people in that office deserve to be shielded from that racist comments.
And I understood, Your Honor. I think if you're simply talking about the nexus element here, it still seems like that is met. Perhaps there's a reasonableness issue. So perhaps the problem is that while the comment might in fact be caused by the disability, it is no longer reasonable. We've crossed the reasonableness line where it is not reasonable to require the landlord's employees to hear those comments. I don't think, though, that there's a nexus problem there. And I believe that we've been primarily talking about this regarding the nexus, the causation between Ms. LaFfan's 2023 attacks and sending the direct emails.
Can I ask, is there inherently a problem with the landlord requiring the tenant to use either a third person or making future reasonable accommodations requests in a form? I mean, one of the problems with the communications here, right, is that they're, in addition to being kind of emotionally charged and hurtful maybe, it's also really difficult to ascertain what is a reasonable accommodations request, what isn't, right? And so a good faith tenant, a good faith landlord trying to sort of needs to know this is actually a formal request I'm making to you that you need to respond to, as opposed to a long email that sort of sounds these themes but doesn't actually articulate it, right? So is there inherently a problem with like requiring the tenant to channel her reasonable accommodation requests through these means?
No, I don't think there's an inherent problem with that at all.
Okay.
I do think, though, that is not a basis on which to affirm the housing court's decision for a couple reasons that I can mention quickly.
Well, this gets, and you can respond to this, but this gets to your initial positions that we should reverse the housing court judge and remand with instructions to enter judgment in her favor. I don't think we can do that. I mean, shouldn't at a minimum the judge make a, if we send it back, make a fact-based finding regarding whether or not the tenant's reasonable accommodations are reasonable in these circumstances, and go through that analysis applying the various factors in the joint statement? That's your secondary position, right?
Correct, Your Honor, and we're obviously not opposed to that position. That is our secondary position. I think it would be possible to say that the direct emails and the late HUD recertification form as a matter of law are not an undue burden on PRI, but I don't think the court has to say that.
Right.
It can
But
absolutely send it back.
This could be a Pyrrhic victory, right? We send it back on remand. There's now, the judge kind of applies the reasonable accommodation standards correctly, in your view, and could well find that the arrangement that was set up through the agreement is reasonable. There is no reasonable accommodations problem, and therefore the non-compliance is an issue, right? That there is no reasonable accommodations defense to the non-compliance. That's a possible outcome here.
I don't think so, Your Honor. I think the only possible way that the court, based on this record, could affirm would be to find.
I'm talking if we were sending it back on remand and the judge were to apply it.
I understand.
Could the judge reach that finding?
Right. I shouldn't have said affirm. I should have said could rule in favor of PRI on a remand. I think the only way it could do that would be if it found that the accepting the emails and accepting the late HUD recertification form was an undue burden that outweighed Ms. Laughen's rights. I don't think it can reach that finding. That's a very high bar, and the burden needs to be on PRI to show it. But I don't know.
It seems possible. There have to be more evidence and more analysis, but that seems like a possible outcome here. You're saying that's just inherently not possible?
I think at the very worst, it's in the housing court's province to figure out that fact-bound determination in the first instance, whether the fact of receiving the emails and having a late HUD recertification form alone without any of the other legal errors and applying the correct legal standard is an undue burden. I don't think it will meet that burden. I think it would even be okay for this court to simply direct that it is not an undue burden. It's a purely past administrative burden. And Ms. Laughen offered at the hearing regular mediations and ways to overcome any effects that those late emails, or I'm sorry, the late form and the emails might have on PRI. If there are no further questions.
Thank you very much. I know we went over because we had a lot of questions, so you'll have fair time if you need it.
Good morning. May it please the court. Caitlin Malone on behalf of the appellee, PRI Glen Grove, LLC. My client would ask that this court uphold the decision that Judge Shearing made on its motion for entry of judgment and the issuance of the execution. My client's position is that the court clearly applied the Bridgewater standard in determining whether or not Ms. Laughen was able to articulate a reasonable accommodation defense that would prevent the entry of judgment and the issuance of the execution. The characterization, I think, that my brother made in relation to the housing court's obligation here, it far exceeds what's expected of the court under the Bridgewater standard. The Bridgewater standard is very clear, and a determination needs to be made if the tenant is disabled. I don't think there's any dispute here that there is a disability, that there's a nexus or causal link between the underlying allegations and the request, or between the request and the disability, I should say, and finally, that the request is reasonable. I believe and would submit to the court that Judge Shearing in the housing court did that analysis and came to the proper conclusion.
Well, I mean, he did do a reasonable accommodation analysis, and I think they have a strong argument that he didn't do everything correctly, right? He required documentation to establish that the disability has a nexus with the reasonable accommodation, which the case law says you don't have to have documentation. You can rely on the tenant in this situation, her testimony itself. And, you know, there was also a suggestion that an accommodation permitting a lease violation or an agreement violation is per se unreasonable. That's not really borne out too. So it seems like there's some legal issues that are with what the judge did with respect to his reasonable accommodation analysis. Do you disagree?
I'd like to respond on 2 points there, if I may. So initially, I'd like to submit to the court that I believe the judge did not reach the determination that Ms. Laughen was not entitled to an accommodation here solely on the basis that she had failed to provide medical documentation. I do not believe that that's what the record reflects here. He does reference that as a point and a consideration that he took in reaching that conclusion, but I would submit to the court and strongly believe that that was not the sole basis upon which that reasonable accommodation defense was denied. Secondly, Your Honor, I would say that the court applied the correct law and that this should be a review of the judge's decision and a clearly erroneous standard should be applied here. That the correct law was applied and that all we're doing is reviewing whether or not that law as applied to the facts here was applied properly and that the housing court judge made the appropriate decision based on those. And so I would submit to the court that Judge Shearing did do that, and that Judge Shearing followed the dictates and the mandates of the Bridgewater's decision.
Who do you think had the burden of proof?
I'm sorry?
Who do you think had the burden of proof on reasonable accommodations?
Sure, Your Honor. So I think it's uncontested in both briefs that at the outset, when the initial request is made, that there is a burden upon the person making that request, in this case, Ms. Laughen, that the request is facially reasonable. And Ms. Laughen was unable to do that. And I'd like to differentiate the Bridgewater's facts versus the facts here. And without going too far down the rabbit hole, Bridgewater, the defendant made the reasonable accommodation request. The trial court judge effectively said, too late, right? We're too late in the case, which everyone agrees was the incorrect decision. But in Bridgewater's was able to articulate very, very clear facts and specifics about the disability, the nature of the disability, and how that disability caused the underlying incident. He was also able to articulate that he had since engaged in further therapeutic services that would address the concerns. Ms. Laughen did not do this here, despite the fact that Judge Shearing gave her ample opportunity during the course of the motion hearing to articulate what had changed since the parties entered into the agreement in 2021, and how her change in circumstances or the progressive nature of her disability impacted her ability to comply with this agreement. She was unable to do that.
Would you agree that if she had an acute episode that exacerbated all of her symptoms, that made her unable to comply with the agreement, that she was entitled then to the accommodation?
No, Your Honor, and the reason why is because the agreement that we did with Ms. Laughen specifically addressed the exact type of conduct that is alleged to have violated this agreement. The landlord accommodated Ms. Laughen, who had previously and resulted in the inception of the summary.
But she has an acute episode. So let's take the recertification requirement. So she has an acute episode. She says she's bedridden. There's no way she can get the information together. You're saying that she would not be entitled to an accommodation in that instance?
She may have, if there was a nexus established between that acute flare-up of the disability and her violation of the agreement. And I think if you look at the record, it's clear that the landlord did accommodate her prior to filing the motion for entry of judgment. So they accommodated her at the time the agreement was entered into, which is clear by the stipulations contained in that agreement, and then also throughout the life of the agreement, so to speak, repeatedly reached out to the counsel that was representing her up until the point of withdrawal and said, Ms. Laughen continues to email the landlord directly. Ms. Laughen has not complied with her recertification obligations. We do not wish to file this motion to issue. Those emails are right in the appendix, Your Honor. And instead of using that as an opportunity to get into compliance, Ms. Laughlin's behaviors continued.
Does there have to be changed circumstances here, right? I mean, there's the initial conflict, and then there is an agreement, right? Both parties enter the agreement. There's no adjudication of reasonable accommodation. Instead, there's this agreement that's reached, right? And then she violates the agreement, and then there's an adjudication of reasonable accommodation. So I know we've talked a lot about changed circumstances, there has to be something different, but I'm not sure there necessarily has to be. You can't contract away your rights to reasonable accommodations
Sure.
under the Fair Housing Act, ADA. So even though it's strange for her to argue that her reasonable accommodation was, or the ability to violate the agreement that she entered into, I'm not sure as a legal matter that's necessarily precluded, but maybe I'm missing something.
I would agree. I don't think it's precluded.
Okay.
And I don't think that the intent of the stipulation contained in that agreement was to have her waive any future rights to a reasonable accommodation. In fact, I think the parties contemplated the exact opposite because they indicated how a future request would be submitted. However, here, I think the court's analysis insofar as, is it reasonable to ask the court to allow you to violate this agreement, which was heavily negotiated by counsel on both sides, and both parties should have been able to leave the courthouse on that day in reliance on the enforcement of that agreement. And this court and other courts within the Commonwealth have repeatedly upheld that the parties should be able to rely on the agreement, most recently in the Dacey v. Burgess case. Now, I don't think it's that she was precluded from raising the reasonable accommodation defense at the motion hearing. That's certainly not my position or my client's position. My position is that Judge Shearing appropriately analyzed it under the reasonable prong of the requirement to make a determination that it was not reasonable.
I don't see that in the decision. He says, first, there are no new or changed circumstances. Second, she didn't submit the required form. And third, no medical documentation. Right? So I don't see anywhere in the decision where he says this request wasn't reasonable.
So I think if you read the order in its totality, I do think that that is the determination that the court made based on those factors. And based on the fact that, and the court specifically references it, that the inundation of these inflammatory emails to the property manager placed an undue burden or placed a significant burden on the landlord such that the request was unreasonable. And while Judge Shearing may not have specifically used that unreasonable language in his order, that I think in reviewing the order in its totality was the ultimate decision of the housing court.
So do you agree that, or is it undisputed that her medical condition has an intertwined physical and cognitive and emotional symptoms?
It's not disputed that she's disabled within the meaning of the law, Your Honor.
I know, but if the disability is just I need to use a wheelchair, that's really different than having your mental functions affected. And she's saying this medical condition, which I think is, based on life experience, it has cognitive aspect to it. She still can't be a jerk just to be a jerk. I get that.
Right. And I think that it's clear, based on the nature of the agreement that was entered into, that there was an understanding that there needed to be this third-party intermediary as a reasonable accommodation to the disability because Ms. Laughen was unable to control the nature of her communications with management.
Who's the third party? Was it the attorney?
It was, Your Honor.
And the attorney withdraws.
But I'd like to draw the court's attention to this, and I think it's very important. The alleged violations of the agreement that were submitted to the court and upon which Judge Shearing made his findings all transpired when the counsel was still counsel of record and still representing Ms. Laughen. That's a hugely important fact here, because I heard Your Honors on, when my brother was arguing, ask whether or not there was a third-party intermediary and ask if there was a reason that a third-party intermediary could not have been used. That was simply not the case. And if you look at the transcripts and the appendix, clearly counsel for Ms. Laughen was involved. There were multiple emails and warnings given related to her noncompliance. Ms. Laughen herself offered an email during the motion to enter judgment hearing in which Mr. Daly reached out to her and talked to her about the fact that she had not been complying with that agreement. So at all times relevant, Ms. Laughen was represented by counsel and continued to engage in conduct that violated that agreement.
So counsel withdrew just a few weeks before the hearing, right?
That's correct, Your Honor.
So what were the reasons for that?
For his withdrawal?
Yeah.
The reasons, it's difficult in a motion to withdraw because you can't obviously disclose any sort of privileged communication. But my recollection was that there was a breakdown in the attorney-client relationship. And just for the record, that motion to withdraw was allowed on February 27th, 2024. If you look at the dates that are referenced as violations in the motion for entry of judgment and issuance of execution, those communications all significantly predate the withdrawal of counsel. And I would ask the court to place heavy stock in that, insofar as whether or not this was an appropriately denied reasonable accommodation by Judge Shearing in the housing court.
Yeah, just in the end, it seems like the critical issue, she made a request for reasonable accommodation, and that being relief from noncompliance with the agreement, right?
Yes.
And the judge kind of summarily concluded, I think, that the defendant's email communications adversely impacted PRI's ability to manage the premises. But of course, some adverse impact is permitted to accommodate the rights of a disabled tenant, right? So the question is, was there really a sufficient analysis? Was PRI forced to sort of make its presentation as to why the requested accommodation, the tenant's noncompliance, imposed an onerous burden, or whatever the right standard is, on itself, as opposed to just letting that adverse effect be self-evident? And I guess that's the kind of the missing part of the judge's analysis as I read the record.
Your Honor, as it relates to that question, I say that maybe things were done out of sequence, so to speak, but I do think the court took evidence from Delilah Callahan, who was the property manager and the plaintiff's sole witness at the motion hearing, that talked about how Ms. Laughen's conduct and engaging with Ms. Laughen in this way impacted her ability to do her job at this 120-unit HUD subsidized property. Specifically, she talked about the nature of the recertifications and how unduly burdensome that they had become. But I think really, aside from the recertification issue, it's the emails, right? It's the ongoing, repetitive inundation of emails where Ms. Callahan actually said, and Your Honor, I believe, referenced these before, these are long-winded emails where it's very hard to determine what is the intent of the email. Is there a legitimate request here, or is this someone airing grievances, or is this someone being intentionally hurtful to someone she has a conflict with? It's really not clear if you read a lot of those emails. And Ms. Callahan said to the judge during that motion hearing, it's very difficult for me to read these emails, one, because for those reasons, but also because they're inflammatory and disparaging and accusatory. And I think the judge did hear that testimony and use that in the reasonableness analysis, Your Honor.
Did anything happen to the subsidy?
So as of right now, Your Honor, there is no subsidy being paid to my client on behalf of Ms. Laughen. And it's important to note that in a property like this with 120 some odd units that are all project-based Section 8 or low-income housing tax credit, my client has contracted with the federal government to do certain things and uphold certain tenets of that contract, which most importantly for HUD subsidized property is to make sure that whoever is living there is continually eligible. And Ms. Laughen, this is not an
about now, but what about at the time of this hearing?
I'm sorry?
You're talking about there's no subsidy in place now, but what about at the time of this hearing?
I don't know if the subsidy had yet been terminated at the time of that hearing, Your Honor.
And the landlord bears the cost of that subsidy being terminated?
Yes. So the landlord would not receive the HAP payment from the federal government if the subsidy is terminated, excuse me, which in this case is a significant portion of the contract rent, where Ms. Laughen's only responsible for 30% of her household income.
Okay. And that's we're several years later from the facts that at trials.
Right.
That's still a problem now.
It is still a problem. If no one has any further questions, I would rest on my brief and thank the court for its attention.
I thank both of you very much. It's excellently argued. The case is submitted and we understand your positions. I also want to thank our court staff for their assistance in accomplishing this sitting this morning. And with that, we're adjourned.
Thank you, Your Honor.